So welcome everyone, and thanks for joining us today for the first in our series of risk webinars. Today we're focused on professional risks and claims and complaints. I'm your host, Paul Marshall. I have Alan Calvert, Laura Fell and Ed Grundy from the professional risks team with me. The team specialises in advising professionals across all sectors on claims and complaints and their insurers and brokers. They help when things go wrong, but they also advise on proactive risk management. So today we're going to look at key risks facing businesses, triggers and trends in claims and complaints, what to do if you receive a claim or complaint, and we'll finish with that proactive risk management side. So starting with Alan Calvert. Alan, when you say the team is advising professionals, what do we mean by professionals?
Thanks, Paul. Well, who's caught under the umbrella professional has increased markedly in recent years, and in general, we would define it as anyone who needs and can get professional indemnity insurance. The team handle cases for the more traditional professions like accountants, solicitors, architects, engineers, and so on, but also under PI policies. We've worked with plumbers, chiropractors, hydrologists, and wedding photographers. Universities, colleges, and schools also now tend to carry PI insurance, and our work for them has increased as a result. In general, we're also seeing an increasing number of clients coming to us looking at tightening up their risk management and complaints procedures, looking at their T's and C's to check they're fit for purpose and things of that ilk.
So looking at how common are complaints and claims these days, Alan?
There was a very telling and entirely accurate quote from the Scottish Legal Complaints Commission in one of their annual reports recently, where they said no matter how good the service solicitors provide or aim to provide, complaints are inevitable. That's also just as likely true for claims, and it spans across all professions and businesses. Whilst that inevitably might seem a bit dispiriting, the message is profound. And the reality is that dealing with complaints and claims is, as SLC say now probably as never before, just part and parcel of doing business, particularly when it comes to delivering professional services. No profession or business is immune to this sort of thing. It's not really about whether or not you're good at what you do. Let's just take that as a given. It's just that there will always be clients who, for a whole range of reasons, might raise issues with services they've received. And it isn't just clients. Increasingly frequently, issues are raised by non-client third parties who are affected by your services, say on the other side of a deal. Businesses need to have a strategy in place for dealing with those issues when they do arise, as they will. Professionals in business regulation and PI insurance has a large part to play when they do.
Great, Alan. So this is what you're seeing day in, day out. So tell the audience a bit more about what are the key risks that businesses and professionals are facing.
There are some key risks which we see coming up time and again. I'm not going to go into some of them in great detail today, as they'll be covered by our experts in those fields in upcoming seminars in the series, but they divide quite neatly into general trends and then some more specific areas. Some of the general issues we see with working practices are, in no particular order, the temptation to dabble in work streams people aren't so familiar with, which can lead to mistakes, under-resourcing, leading to staff not having time to do work properly or things being missed entirely, lack of supervision, particularly with hybrid working, too much of a hurry leading to a ball being dropped. We've seen cases where professionals have done everything perfectly right up to the last minute, and then a change is made, and they forget to apply the same professional rigor they would normally, solely because of time pressures. We also see failures to follow through in post-transaction issues. There's a tendency, and it's only human, after a fee's been paid, to want to move on to the next transaction, but that also carries the risk of losing sight of issues and not receiving the client's ideal outcome. For lawyers, that can be not registering the deeds transferring title to a property, or for accountants, not lodging necessary documents with Companies House, or for architects or building contractors, not obtaining a habitation certificate. We've seen all of those causing expensive and time-consuming problems. Problems can also escalate purely through poor management of the situation, where they might have been resolved at an earlier stage if handled correctly. In terms of some specific areas we're seeing an increase in claims in, fraudulent activity is on the increase and is getting more sophisticated, as we all know. Data protection and cybersecurity risks are also increasing as cyber attacks become more sophisticated, and the use of environmental, social and governance or ESG factors to assess the sustainability of businesses is also an emerging area where we're seeing claims and complaints.
Thanks, Alan. Now, Ed, Alan there is saying it doesn't matter what you do or how good you are, there are going to be claims and complaints. So can you tell us about some of the triggers that you see? How did complaints and claims come to light?
Yeah, so as Alan said, unfortunately they're inevitable. So in terms of what people complain about, unfortunately, some people, as we know, it's just to be difficult. In the majority of cases, though, there are some typical triggers lead to complaints. So in our experience, they tend to be about the kind of service that's been delivered, as opposed to just getting the advice wrong. Obviously, we see that as well, sometimes through a lack of knowledge or other things like poor succession planning, unprepared successors, or work hasn't been handed over properly. So there's sort of three main categories for the triggers that we see. So communication, tone, and result. So poor communication is a big source of complaint. So it's been reported over 40% of complaints to professional bodies relate in some way to this communication issue. Can simply be about the manner in which the communication is made or the frequency of the communications. Sometimes it's just a perception that the work's not been done. In our experience, that's actually hardly ever the case, hardly ever about laziness or incompetence. Just often it's about the client having unrealistic expectations through a lack of clear communication about what they're likely to get at the end of the process. So good communication is often just about managing those expectations well. So I said the second was tone. So it's a softer skill issue. Obviously, we get complaints arising from tone issues. Sometimes it's a lack of respect or a personality clash, failure to show empathy, keep trust in the relationship, or just being aware of issues that are actually important to the client. So having empathy or good demeanor with the client shouldn't be underestimated in mitigating the risk of complaints. And finally, as you'd imagine, complaints arise in relation to the result. Again, we mostly see them if the expectations aren't managed properly or unrealistic. So talking about that and what might happen and the possible outcome can be time well spent to avoid complaints in the end. Timescale and cost are obviously two key triggers for complaints, as you'd imagine. And while things do overrun, setting those realistic expectations, keeping a dialogue open can minimize the risk of a complaint. And also issuing smaller regular fees can be more palatable to clients rather than a cover-all fee at the end.
Right, so really helpful there to understand what are things that can be done to stop those triggers from being pulled in the first place. So Laura, if I can turn to you now, and Ed dealt with the triggers, but what about trends? So what do you see in complaints and claims at the moment? I suppose two things that occur are, did COVID-19 have an impact on complaints, and is the current financial climate having an impact on complaints?
Sure. Well, the instance of complaints actually reduced significantly following the pandemic, but there does appear to be an increase happening now. So we've been anticipating a spike in claims as a result of the work environment created by COVID-19, particularly in the early days when there was a lack of supervision of staff perhaps, or delays while everyone was getting up to speed with remote working. And while we have seen some of those claims coming through, those aren't really in the volume we anticipated, but we do think there might just be some issues lurking there, so some issues yet to be discovered. Economic downturn, we do always see an increase in risk behaviours and claims and complaints in those periods. Clients who are suffering losses will look to the advice they've received from their professional advisors and businesses to see if there's somewhere they can recoup some funds. In terms of risky practices, professionals might be more tempted to dabble, as Alan mentioned earlier, so they can get some more work through the door. The risk of fraud also increases. That presents a risk in terms of internal embezzlement by staff, but also professionals such as accountants and auditors. Businesses might be suggesting that they should have been picking up fraudulent behavior themselves. And also sort of cyber attacks for ransom might also increase in these periods.
Okay, and that's really helpful. Are there particular sectors during a downturn that you'd expect to see impacted and there'd be more claims there?
Yes, definitely, particularly in property and finance, as well as claims against directors and officers. So in the property sector, we always see claims by lenders in a property market crash. And it does unfortunately appear that one might be on its way. It's recently been reported that house prices fell by over 5% in the year to September, and they've got further to drop. So that's likely to lead to borrowers and defaulting and increased repossessions, and lenders are going to look to surveyors, valuers, solicitors to recover any shortfall. Also, property managers and estate agents, as utilities and other costs are increasing, so will service charges, leading to more scrutiny and dissatisfaction by owners. And some brokers we've spoken to have also been talking about rack concrete and wondering if it's going to be property managers that are going to face those claims, because the contractors and construction firms are likely to have time-barred claims. On the finance side, uncertainty in the markets makes people look at their investment advice they've received and see if there might be a rise in complaints against financial advisors. And also, as corporate insolvencies increase, we'll see claims against IPs and, for example, by creditors alleging sale of assets under value, and then in turn, IPs against their own advisors. And on the director's side, increases in insolvencies will also lead to increase in litigation against companies and directors by their shareholders, IPs and employees. And also these new ESG regulations, etc., will also be causing issues for directors and liability insurers. So generally, professional advice and work done will be coming under the microscope in these periods.
Great, thanks, Laura. I probably should have said to you what sectors are not impacted by the downturn. That would have been an easier
Yeah,
question.
Definitely.
So Ed, I mean, you're a hip guy. We all know that. Social media is your thing, but we know that social media has that potential to blur personal lives with professional lives. Is it fair to say that social media increases the risk of claims against professionals?
Yeah, so I'm glad that's the vibe I'm putting off, Paul. Obviously, it's something we're seeing more often now, and like you say, it's definitely that blurring of personal and professional lives. So I presume most of the people in the session will have some form of social media. Obviously, I've got a variety from professional platforms with LinkedIn to personal things, Facebook, Instagram, and Twitter or X, whatever it's called these days. But all of these types of social media come with their own risks. So we've represented individuals facing disciplinary proceedings due to behaviours online, completely separate from their working life. One client was investigated, so a friend uploaded a photo of him to Facebook in, I think we'll call it a risque position. It wasn't the friend that lodged the complaint to the regulator. They were not offended at all. However, that unrelated third party saw the photo on Facebook, was offended by it, reported our client to the regulator. We were actually able to get the complaint wholly rejected, but it had pretty damaging reputational issues for the individual. It's obviously pretty stressful, and the business was impacted in the short term as well. We've also had another individual who's a fan of an old firm football team, posted a series of tweets he thought were funny, taken collectively. A third party saw them, thought they were an expression of offensive religious views, and it ended up before a regulator. And I think I'd say we're not here to say what people can and can't do online. Obviously, we can't and shouldn't stop people from using social media. But we've all seen examples where people have got themselves into a bit of bother online, or headlines about behaviour at, Christmas parties are a famous one for this sort of thing. The individuals themselves are obviously in a tough situation when these things happen, but often the business and professional firm they work for are also named, can suffer reputation damage as a result. So we just want to suggest caution with using social media for private purposes and business purposes, and for the businesses themselves to have a social media policy and ensure that staff are clear on what's appropriate and the risks posed, just to sort of mitigate that sort of risk, really.
Thanks, Ed. Well, you've frightened the life out of me on social media with that answer. So thanks for that helpful reminder. Now, if we still with you, Ed, if we start to look to the future, and that's almost a really heavy Christmas party connection, isn't it? Looking to the future, yeah. It's only just begun, etc. Now, what are the next big things we're going to see for claims against professionals? What's coming down the tracks?
Yeah, so I suppose one of the main areas we see a risk is generative AI. So the most famous of this, ChatGPT. So AI can present opportunities for businesses, but it's also important for everyone to be aware of the risks they entail. So if there's an over-reliance on them or failure to cross-check, AI-generated content can lead to incorrect information being provided. So there's a famous one recently, an American lawyer lodged arguments in court, been created using ChatGPT. It completely made up some of the information and several of the cases referred to. So he got a pretty public dressing down by the court, so much so that, you know, we've heard about it over here in the international legal news. So that's one area. There's technical limitations, but also data breach, privacy issues with confidential information being put into open source software. So it's really important for businesses to have appropriate procedures and safeguards, to include human oversight to check AI content and have those clear policies in place. I suppose a second area are claims in relation to inclusion and diversity. So discrimination claims are expected to rise in the current climate where diversity is being championed. Policies and procedures, again, should just be reviewed to ensure they're fit for purpose in the modern working world. Staff training and education is also important. And the final area, so Laura and Alan mentioned about ESG. So ESG adjacent issues, businesses can be tempted to overstate ESG credentials or inadvertently make inaccurate disclosures or representations, and the FCA are looking to really clamp down on greenwashing by companies. So people providing that advice that forms the basis of those misrepresentations or greenwashing issues can face professional indemnity claims. Either that's just through giving a small bit of advice, or if you're giving specific ESG advice or, you know, shaping ESG strategies, claims can be on the rise from that.
Great, thanks, Ed. Now, Alan, the thing here is Ed and Laura have just spent the last few minutes with a really sophisticated analysis about where claims and complaints are coming from, what are the triggers, what are the trends. But right at the very beginning of this session, you said it doesn't matter what you do, the claims and complaints are going to happen anyway. So let's go to the Alan Calvert world where the claim and the complaint happens. What should you do if you receive that dreaded correspondence through the letterbox or through the email?
The key thing is to involve your insurers early. There's two elements here. When should an issue be notified to insurers, and what coverage will the insurers provide when there has been notification? Looking first then at how to notify a matter to insurers, the steps you need to follow will depend on the terms of the policy in place, but there are usually stringent obligations to notify insurers, which is commonly done through your broker, as soon as there's a circumstance that might give rise to a claim. Brokers can advise on this if you're in any doubt. Typically, notification will be needed as soon as there's an allegation of something having gone wrong, even if you think that the criticism is unfounded. You should bear in mind that there can be a need for a circumstance to be notified long before any court action is raised or even threatened. I have seen cases where businesses have been told by their advisors, even their lawyers, that they needn't notify insurers unless the word claims have been used. That's simply wrong, and a matter usually becomes notifiable wherever there are circumstances which might give rise to a claim. Not notifying potential claims promptly can have serious consequences. It can impact upon the degree of cover available, for instance, and we've seen many situations where a business has attempted to sort the matter out itself and only created further issues. Don't forget too that policyholders are usually obliged by their insurance contract to cooperate with insurers and not do anything prejudicial to the handling of a claim. To take just one example, where there's late notification, we can discover that policyholders have made an apology or admission of wrongdoing, which is almost always in direct breach of policy terms. That situation can be pretty difficult to roll back from after the event. If there are multiple related claims, or if there's a claim and a separate regulatory complaint being pursued in tandem, usually separate notification will be required for each, even if they arise from the same circumstance.
Great, Alan. So look, the first bit there is you've got to tell your insurer when the circumstance arises. That's your side of the bargain. What's the quid pro quo? What will the insurer be doing to protect your position?
Firstly, it's worth just setting the scene and the practicalities and what the insurer will actually do when a claim is notified. They'll decide, usually after discussion with the policyholder or broker, whether to become involved at all, and if so, to what extent. They may be content for the policyholder to continue to deal with the claim direct, so long as they keep the insurer up to date, or if the insurer wants to take a more hands-on approach, they might deal with the claimant direct with no legal input. Often, though, they'll appoint a solicitor to either give advice in the background or engage directly with the claimant. What they do depends on the circumstances, but lawyer involvement is more likely if a matter is complex, contentious, has been litigated, or especially if a formal complaint's been made to a regulator. Generally, the insurers will appoint lawyers from their own panel of firms. However, as a policyholder, you and your broker can certainly request a particular firm or another firm entirely. Whether or not the insurers agree to that is almost always a matter solely for them. Looking at coverage more generally, the insurance cover under a PI policy usually relates predominantly to third-party claims for compensation, payable as part of a claim or regulatory complaint. The PI policy also covers legal defence costs, from investigation costs through to costs of dealing with court proceedings, as well as the other side's costs, if the claim succeeds. PI insurance generally doesn't cover penalties or fines imposed by regulators, and practices should be aware of the limits of their cover and anything that's specifically not insured. There is, of course, usually a policy excess payable by the business towards any successful claim, and your insurance schedule will set out the details of that. However, everything I've said today is all by way of general observations, and as I've said throughout, each policy will turn in its own terms and the particular circumstances of the policyholder and the claim. So check your policy, and if in doubt, consult your broker, who's usually best placed to advise on these issues.
Great, Alan, thanks for that. Now, until this point, we've been spending a lot of time looking at what happens, or how do complaints arise, and what do you do when the complaints have arisen. We're going to try and flip it for a second, Laura, and come to you and try and get ahead of the problem. So let's talk about what a business can do to plan for or prevent complaints. So could you start maybe with setting up the business relationship, and what are the good things that a business can do at that stage to protect against the risk of complaints from clients?
Thanks, Paul. Well, clearly defining the scope of work you're doing for a client is really important. So that's something that should be set out in writing at the outset of the instruction, whether that be in a letter of engagement or another document setting out the terms and conditions applicable. There's probably three key points to mention there. We've all usually got these standard terms and conditions, and that's great from a consistency perspective, but it is important to remember to revisit those regularly and make sure they're fit for purpose, and particularly to avoid mission creep. So having a system in place to prompt you to do that review is important. We regularly see people operating out with the scope of their letter of engagement and opening themselves up to claims they might not otherwise have been liable for as a result. So do keep an eye on how instructions develop and whether an updated letter of engagement is required. Secondly, limits of liability. That's something that should be specified in the terms and condition, having an upper limit for any exposure to compensation in the event of a claim against the business. So many will have a standard cap or a standard method for arriving at a cap, which will suit the majority of instructions. But it's important this limit's appropriate both for the nature and value of the work being undertaken, and also that it takes account of the insurance cover in place and what PI insurers will cover in the event of a relevant claim. So by way of example here, we acted for a professional facing a claim of around 18 million, and that arose from a piece of work where they were paid £30,000. So the claim was actually beyond the limit of their insurance, which was 10 million. So I'm sure you'll agree those are quite stressful numbers. So thankfully we were able to defend the claim in full, but it just demonstrates why it's important to think about the scope and value of the work and set a suitable liability cap. So it's not to say liability caps not going to be challenged, and whether it's successful will be down to the facts and circumstances, but it is a handy first line of defence. And the third point just to mention on that is who can rely on a letter of engagement. So it's important to consider whether third parties might want to try to rely on the work product if it comes into their hands, including any advice that's been given. So you need to give consideration to whether there should be some specific provision in a contract or in any advice or on the reports given about who's entitled to rely upon that, particularly in multi-party projects.
Great, thanks, Laura. Now, before we're coming towards the end of the structured part, I've been keeping a very close eye on the questions coming into the Q&A. So just to give everybody a chance, you've got a few more minutes to put your questions in before we put those to the guys. So like some really difficult questions for Alan and Ed and Laura, please. But we'll come to that in a moment. So we're coming to the end, Ed. You are our closer, our finisher today. So can you tell us, what are your final top tips for risk management, protecting against the risk of claims arising?
Thanks, Paul. Yeah, so I suppose, as I mentioned earlier, communication and managing expectations is a key part of everything. So within the organization, internally publicizing risk management procedures and practices, and then obviously with clients and customers and third parties in terms of timescale, cost, and as Laura said, scope. Colleague training and culture are another key aspect to reduce risk of complaints. You need staff to know what the risk management practices are, how policies are with handling complaints, things like that. Regular training and workshops and policy reviews can help on that element. Staff in your business need to feel supported to communicate their concerns without the risk that they're worried they're going to get into trouble. Everyone makes mistakes. They need to be able to report things without fear of reprisal quickly, just so damage limitation can be undertaken as soon as possible. Having that no blame culture is as important as any other risk management tool, we think. Personal favorite of mine, record keeping and taking file notes. We have a lot of cases where good records or file notes of meetings are available. We're able to just produce those, defend the claim immediately. On the flip side, if they're missing or the process just becomes more complicated, it's more of a he said, she said, it's more time consuming, more costly and harder to defend. So it's more stressful for everyone. So as Alan said, dealing with these complaints in a timely manner, rather than, in an effort to diffuse rather than aggravate things. I think having a designated personal team to do that, having a process in place helps immensely. Proactive risk management helps to avoid claims and complaints and puts you in the best possible position to defend them. And it also, in terms of the actual running of the business, it helps to, when you're looking to renew policies for professional indemnity or D&O insurance on the best possible terms. And finally, we would say it, but seeking professional advice is helpful, not just to make the decisions, but sometimes at a later stage to justify those decisions and improve the prospect of maintaining the insurance coverage or defending the reputation of the professional or the practice.
Great. Thanks, Ed. Really helpful summary of key points there. Now, the questions, I'm trying to the Q&As, we've got a couple of minutes, so we'll try and fire through some of these. First one, I'd probably have to come back to you, Ed. It's on social media.
Yeah.
How does it envisage the potential impact on business, or what's envisaged to be the potential impact on business of the new Online Safety Act?
Yeah, so I think with that, it's obviously not come in just yet. I think it's about to get royal assent. And I suppose it's going to be interesting to see in the short term what's challenged, because from what I understand, there's going to be a lot of challenge from some of the social media companies. And I've heard WhatsApp are planning to just ignore it entirely. So it's going to be interesting to see where the lines are drawn and where it's challenged in court to see what it can actually do. But in terms of the effect on business, I suppose it's easier to manage in terms of the policies we were talking about. Having a policy in place, it's easier to define if something falls foul of this, that's not acceptable, rather than at the moment there are grey areas of what's personal, what's professional. It could be easier with the policies to put this in place. And I suppose if you fall foul of the Online Safety Act, it's not acceptable. It's probably one way that we'd see it actually changing things, but we need to see what the courts think of it in the end, I suppose.
Great, thanks, Ed.
The only thing I'd add to that is that it
Go on,
will increase awareness of the public in general and possible claimants who may look to the Act to just have another string to their bow in any claim against a professional or business.
Great. I'm going to squeeze in one more question. Sorry, it means there'll be a couple of questions we don't get to, I'm afraid, but we'll reply to those after the session. But the one I'm going to squeeze in, Laura, can I ask you to pick it up? It's a question about agile working and what impact agile working has had on risks for professionals.
Sure. Well, in general, obviously the hybrid world's certainly changed things, probably both for the better and the worse. Everyone's working at home more, we're all working on the move more than ever before, but it's probably harder to get into the same collaborative approach and culture as before. And I think all companies are pretty aware of that and are making efforts to get the balance right. In terms of particular risks, we've seen a rise in complaints to regulators and also cyber crimes and claims arising from those. Working from home seems to have increased cyber risks for professionals in particular. We've acted in several cases where monies have been sent to the wrong party due to cyber criminals having intercepted emails and professionals not having verified those details by phone. So making sure that IT systems, physical systems and training are appropriate for the new working world to identify risks and guard against these deliberate attacks, they're all things we'd recommend. And data breaches is also obviously a key issue to keep on top of as well. So important to examine. We've got up-to-date IT systems, physical systems, and having lots of training in place.
Great, thanks, Laura. I'm sorry, everyone, our time is up. I can see some more questions which we'll need to come back to you on. We will do that. I want to close a couple of summary points. Clearly, you're going to do everything you can to prevent claims from arising, but the team have explained that you're not going to be able to prevent claims and complaints arising. You will have policies and procedures in place to manage risks as best you can, but when that dreaded thing happens, seek advice, speak to your insurers in early course. There are important things I've taken from the session today. So can I close by saying thanks to Alan, to Laura and to Ed for taking us through the wonderful world of professional risks. And thanks to all of you for joining us. Thanks for joining us today. And for now, thank you and goodbye.